We shall now see the facts of another well-known English case and then answer the question whether, on these facts, a valid contract came into existence. This case was decided by the Privy Council in 1893. The case is titled as Harvey versus Fessai. The entire case is based on three telegrams, two from Harvey and one from Fessai. Here are the three telegrams. The first telegram is from Harvey. He wants to purchase a property belonging to Fessai. He is putting two questions to him through this telegram. Will you sell us Bumper Hall Pen? Bumper Hall Pen is a property belonging to Fessai. The first question Harvey asks is whether Fessai will sell Harvey his Bumper Hall Pen. Second question is telegraph lowest cash price. In reply, Fessai sends a telegram. He answers only the second question and he says lowest price for Bumper Hall Pen is £900. Then the third telegram from Harvey, in reply to this telegram from Fessai, Harvey says, we agree to buy Bumper Hall Pen for the sum of £900 asked by you. The question is whether these three telegrams form the basis of a valid contract between Harvey and Fessai. Whether Fessai is bound to sell his Bumper Hall Pen in the quoted price of £900 to which Harvey has agreed. These questions were decided by the Privy Council, and that is how the Privy Council first analyzed the telegrams and then decided the case. I am now showing you important portions from the judgment directly. Here is the analysis of the telegram. The first telegram asks two questions. The first question is as to the willingness of Fessai to sell to the appellants, that is Harvey. The second question asks the lowest price. Fessai replies to the second question only and gives his lowest price. Here is the decision. Their lordships cannot treat the telegram from Fessai, the second telegram, as binding him in any respect except to the extent it does by its terms with the lowest price. By the second telegram, Fessai is bound only by one thing, by the lowest price, nothing more. Everything else is left open. And the reply telegram from the appellants, that is Harvey, cannot be treated as an acceptance of an offer to sell to them. Rather, the reply telegram from Harvey is an offer that required to be accepted by Fessai. The contract could only be completed if Fessai had accepted the appellant's last telegram, that is the third telegram. So one more telegram was required from Fessai accepting the offer given in the third telegram. Their lordships are of opinion that the mere statement of the lowest price at which the vendor would sell contains no implied contract to sell at that price to the persons making the inquiry. This is an important statement of law. That statement will apply to every such case where there is an inquiry from a purchaser regarding the lowest price and where the vendor quotes the lowest price. That by itself is not an offer. The offer has to come thereafter from the purchaser, and subsequently the vendor has to accept that offer. Then and then only it becomes a valid contract. The Privy Council says that the statement of the lowest price by the vendor contains no implied contract to sell at that price. When he quotes the lowest price, there is no implied contract to sell at that price. He may not sell it. What is the significance of this case? This case defines the difference between an offer and supply of information. This is again very important. The second telegram in this case was merely a supply of information. It was not an offer. The vendor was only quoting the lowest price. This is just an information. It is not an offer. So this case defines the difference between an offer and supply of information. The Privy Council held that the indication of lowest acceptable price does not constitute an offer to sell. It was not an offer to sell from the side of the vendor. Rather, it is considered an offer to treat. It was an invitation to enter into negotiations, that's all.